Good evening, everyone. This is the Carver Zoning Board of Appeals meeting for the date of March 22, 2022. We are in attendance at the Carver Town Hall in meeting room 4. We have some administrative matters to attend to, the first of which is approval of minutes that were generated following the last meeting of February 23. Has everyone received a copy of those minutes?
Yep.
Yes.
Has everyone had an ample opportunity to review those minutes?
I did.
Yes.
Does anyone have any changes, amendments, or modifications that they would like to make?
I do not.
Everybody good?
Everything's good.
I will entertain a motion.
Motion to accept the minutes.
Do I hear a second?
Second.
All in favor?
Aye.
Thank you, friend. Those meeting minutes are approved. Before we go any further, and for the sake of making sure that there's proper procedure, I'm sure everyone can observe tonight that our 5th meeting member, Fran Mello, is with us via Zoom, and we see her and hear her clearly, and you can do likewise. Is that true, Fran? You can hear us and see us, okay?
Yes, I can.
Okay.
Yep. I'm going to mute just so that you don't get any background noise, but I can unmute and talk.
Very good. So what I'd like to do is ask the board if they are prepared to accept Member Mello's participation tonight, video and audio participation for this meeting.
Yes.
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 And yes from the chair as well. I'll entertain that motion that Ms. Mello be allowed to participate remotely in view of the fact that she has indicated that she can hear us and see us and vice versa. I will entertain that motion now.
So moved.
Second.
All in favor?
Aye.
Aye.
So, Ms. Mello, you're in.
Thanks.
All right. So with Ms. Mello's participation, and I do want to ask you, you've received all the pertinent documentation on the cases for this evening. Is that true?
Yes.
And you've had an opportunity to review all of those submissions for all the cases that are on the agenda this evening. Is that true?
Yes.
Okay. So despite the fact that you're with us remotely tonight, you feel as if you're fully prepared to participate in discussions and votes concerning these cases. Is that true?
Yes.
Thank you. I'm going to take matters a little bit out of order this evening on the agenda. The first of these cases that's listed that I want to get to is referenced in paragraph E, which coincidentally is the last case on the written agenda. That is case number 100-6-0R, the petitioner being Wenham PV1 LLC. And there's a notation on the diary, or on the agenda here, that this case is now been continued to May 3, 2022. Does everybody see that?
Yes.
Yes.
So just for purposes of educating the public and for those watching at home, that particular matter referenced in subparagraph E on our agenda was previously moved to the May 3rd, 2022 meeting. They've got some more background that they would like to do. The next case that I would like to go to is referenced in paragraph C. That's case number 1-20-0R, the petitioner being Richard Antoniotti. And he has filed a written request with the board asking for a continuance concerning the property located at 92B South Main Street. This is a case where he's looking to extend 2 pre-existing non-conforming structures on a lot to make each existing building a 2-bedroom structure in a residential agricultural district. So he too had some things that he needed to attend to, and ask this board to continue this case. We don't have a date yet because we didn't vote on this request for a continuance, but do I hear a motion to allow that continuance to occur?
So moved.
Do I hear a second?
Second.
All in favor?
Aye.
Let's talk about the, thank you. Let's talk about the next date, which is a May 3rd date. As I just told everybody from the previous matter that I referenced. Is everybody good with the May 3rd date? This will be our second case.
Are they asking for May 3rd? Because we have a meeting scheduled for April.
They're requesting a continuance but did not give a specific date. And I think given the fact that he's got to go before conservation, and I think, did we say that he also would be well advised to go before planning as well?
The Board of Health.
The Board of Health. So he's got at least two
Right.
boards to go
Okay.
to.
It makes sense.
Yeah, so I think you folks are right, maybe the May 3rd date. So do I hear a motion to continue that matter to May 3?
So moved.
Do I hear a second?
Second.
All in favor?
Aye.
So we're granting this request of Mr. Antoniotti on that particular matter, and it goes over now to May 3rd. Is Ms. House, there's Ms. House. It's nice to see you again. I feel like we're getting to know each other very well.
We have openings.
We have an opening. Let me read this into the record, and then we'll get back into this again. This is subparagraph D on our agenda for this evening. It's case number 82-1-1R. The petitioners being Keith and Carol Howes, who are requesting a special permit pursuant to sections 2245C, 5221, and 5300, and sections following of the Carver zoning bylaw for property located at 223 Meadow Street in Carver. Assessors map 82, lot 1-1-R, so as to construct, at least this is what you applied for originally, so as to construct a 30 by 60 square foot detached garage. That's 1,800 square feet. Maximum allowed is 700 square feet per the bylaw, all in a residential agricultural district. So just to let everybody know tonight and who's watching, this particular case has come before us. I think this is the third time you've been with us. Is that true? And the plans have been evolving as we've gone through this particular project request. And they have downsized. We realized that there was going to be a second floor, so we had to add that square footage in. So we're now at a point where you're going to tell us, I think finally, and for the last time, not that we don't like seeing you, but for the last time, we hope, what your plan is now for this proposed structure.
Mr. Chairman,
Yes.
I am not sitting on this case.
So we now have a situation similar to the last time, where we're down to a board of 4, and you know what that means, right?
Yes.
We have to be unanimous in order to grant you the relief that's requested.
Yes.
One member votes against, and it goes down.
Yep.
Are you prepared to go forward this evening?
Yeah, I think so.
Okay,
Yeah.
all right. Not that we wouldn't mind seeing you back if that's what you wanted. Okay. So, Ms. House, I feel like I should be calling you Carol after all this time. What would you like to do now?
Well, after I did speak with the new building inspector and conversation with him, and I did reduce the size. And it seemed, and as far as the documents go, it seems like it's what was needed. And I think we're ready to go for it. It's mainly the size that we're,
Okay. Is there any change to your plan?
other than the size, no.
And what are you doing with the size?
I reduced it from 30 by 60 to 28 by 50.
Somebody do the math.
Yeah, somebody got a calculator?
It's 1,400.
28 by what, I'm sorry? I missed
50.
that.
50.
28 by 50. Is that including the second floor?
The second floor, according to the wire inspector, isn't, he said it's part of the square footage, whatever
It's
the
not.
square footage of the building is.
It's
So
not.
at this point, we're shelving. We're not going to worry about a second floor.
So what's going to be up there now?
Nothing. It's just going to be an open space. Because the point of the height was for the back door anyway, so.
Okay, all right. So 28 by 50, what did you say that was?
1,400.
1,400.
Yeah.
So that's considerably smaller than what it was before. Because I don't think we've ever permitted a garage of this kind larger than 1,800 square feet. Is that true? Is that-
I don't know if it's gone that high. I'm not even sure it's.
No, I remember one that went that high. But, Ms. Mello, do you remember the biggest one that we did?
The research that I did, looking into this case was 1750.
Okay,
All
well,
right, pretty close.
fair enough.
Yeah.
Pretty close. So the second floor is not going to be, there won't be a floor up there, is that?
No.
Okay, and that's what counts towards the square footage?
Yeah, it added to the space.
And not if you have like a hippity hop across the barber shop kind of situation where you just have beams laid and you kind of hop along to
Yeah.
put your stuff in a corner or something up there. If there's no full floor, then we're not going to count that.
Right, which I didn't understand the wordage at the time, so as far as I'm concerned, it's, you know,
There's a lot I don't understand too.
it's not going to be a second-story closed-in room for living or, you know, anything with a door or anything of that sort.
Okay.
It's not going to be that, so. it's
So let's
storage.
briefly recapitulate here. The second floor is gone. You've reduced to 28 by 50, which is 1,400 square feet. You're still going to need relief on the size. The proposed height of the garage remains the same. It's about 19 feet, right? The house on the lot is about 23 feet at its peak, right? You've obtained some additional drawings and plans that were helpful. At the last meeting, you gave us those new drawings. They're now part of the file. And here you are back before us with the downsized plans. And those plans you gave us the last time, were they the 28 by 50? And did they depict a second floor with a, okay. Those are all my questions.
Water, you're going to have any kind of water, electrical,
Only for the garage purposes, you have the, you know,
for the
garage door.
door and the lighting and that type of
Yeah.
thing, right? Okay.
So no electrical inside except for the door?
I don't know if you would need plugs or, you know, for like vacuums or something of that sort that you might use inside a garage.
We won't limit you, or at least I won't,
Yeah.
but water, no. Mr. Poirier?
Those were my only two questions.
Ms. Mello, do you have anything?
No, I'm good, thank you.
Mr. Barrington?
All set.
Okay. We have a full house here tonight, and I want to ask if anyone has any comments or questions that they would like to propose at this point in time. I see no one interested in making a remark with regard to this, so let the record reflect that the public did not oppose this. Do I hear a motion to close this hearing?
So moved.
Do I hear a second?
Second.
Second,
All in favor?
Aye.
I,
So we are now closed, and now we have to make a decision. So, this is a request for a special permit. I think it outlined magic language. And that is, we want to make sure, if I brought my magic language, that we have this correctly. Why don't we look it up in the book? Special permit. Oh, wait a minute, I think I just found it. All right, here it is. I suggest that the board make the following finding: that the benefits of the proposed use outweigh its detrimental impacts on the town and the neighborhood in view of the particular characteristics of the site and of the proposal in relation to that site. Somebody want to make that motion?
So moved.
That we enter this finding. Second?
Second.
All in favor?
Aye.
Okay. And now our decision. I suggest the following language for the decision: that a special permit be granted under Article 5, Section 5330, as the benefits of the proposed use outweigh its detrimental impacts on the town and the neighborhood in view of the particular characteristics of the site and of the proposal in relation to that site. Do I hear anybody wanting to make a motion to adopt that language for our decision?
Motion to adopt.
Second.
All in favor?
Second.
All in favor?
Aye.
Aye.
Next, I want to go to conditions. Does anyone have any conditions that they would like to attach to this grant? Let me prompt everybody by suggesting that maybe we need to consider a water condition.
Yep.
And obviously a condition relating to the most recent iteration of the plans as submitted.
Okay.
Yep.
Ms. Mello? Okay, so do I hear someone willing to make a motion to be sure that there is no water in this structure, and also that it is subject to the plans as submitted to this board?
So moved.
The most recent plans, I
Most
should
recent
say.
plans, yep. So moved.
Second?
Second.
All in favor?
Aye.
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 We're going to miss you. Congratulations, final.
Thank you.
I hope your husband's feeling better.
Well, he may not be driving his truck anymore, but we shall see. He's
Well,
still in a wheelchair.
he can
so-
putter around in the garage,
Yeah,
how's
we'll have
that?
more space in the garage now.
Okay.
Okay, so,
So I'm the one that usually writes these decisions, and they have to be written and filed with the town clerk in 20 days. I'm usually quicker than that. So anyone who wants to appeal this decision has to do so within 20 days of the date that this is filed with the town clerk's office.
okay.
So you can't do anything yet, because you got to wait for that appeal period to pass. And then you coordinate with the building commissioner and get cracking.
Okay.
By that time, and you got to record this decision at the registry of deeds. Is that what you're going to say?
I was going to say that the town clerk will call you when the decision's ready to be picked up, and she'll give you the original copy, and you take it down to the registry of deeds on Overy Street, or you can mail it in, but that takes a little bit longer. And then once it's recorded, you can come back to the building department, show that it's been recorded, and you can get your building permit then.
Wonderful.
It's not going to be 20 days before you see this.
It's okay.
Okay, it'll be done before the end of the week, or by the end of the week.
Great. Thank you.
All right.
you.
Have a good night.
You too.
And
Good luck. Yep.
Paperwork is all jumbled up. That's good. Bear with me for a minute. Okay. And so we now come to our last case of the evening, the one that everybody appears to be here for, and that is paragraph B on our agenda for this evening. I think we've cleaned up everything else. Public hearing on case 32-1-A, 1-1, 1-2, 1-3, 1-4, 1-5, and 1-60. The petitioner being Margaret Sheehan on behalf of Save the Pine Barrens, Inc., appealing the denial of the building commissioner for enforcement of the Town of Carver zoning bylaws with regard to earth removal activities on land owned by Ricketts Pond Business Trust. Said activities allegedly occurring at property located on Spring Street and Route 44 in Carver. Assessor's map 32-lots 1A and then 1-1 through 1-6 in the Spring Street Innovation District pursuant to Massachusetts General Laws, Chapter 40A, Sections 8 and 15, as well as under Sections 2230 and 5223 of the Carver zoning bylaw. Who is here representing the petitioner this evening? Could you
Good
identify
evening.
yourself?
Yes, Donna Brewer, counsel for Save the Pine Barrens, Inc. and its members.
Nice to see you. Thanks for
Very
coming
nice to
tonight.
be here. Thank you.
And Counsel, a specific question for you before we begin. As you see that we have one of our members who's participating remotely tonight. Does the petitioner object to that participation?
No, sir.
Okay. For the record then, you're still good.
Thank
I mean,
you.
you're good anyway, but you're still good for this evening.
Officially good.
Yes. Okay. Ms. Sheehan can tell you, and I will repeat for what it's worth, that we are careful about reviewing everything that comes to us before our meetings on the merits begin. So, although we'll certainly allow you some time to go through your presentation this evening, consider that we are already well-educated based upon your submissions, your letter, and maps and everything else that's pertinent to this case in this file. Unlike a lot of judges who wing it when they get on the bench because they've never opened the file, as you and I both know. Anyway, we have had a similar case come to our attention recently on which we issued a decision. That's case number 131-2 with regard to property located on Federal Road and Hammond Street, Goldenfield Solar, Federal, aka Tihonet East Solar, and Zero Hammond Street Solar. Are you familiar with that decision that we rendered? Okay. Then what I need to do is give you mine, so long as you give it back to me. And what I'm going to do, out of courtesy, is suspend briefly so that you can have an opportunity to look at this. I don't want you to have to try to read through this and listen to me at the same time. So, for the next, let's say, 10 minutes, is that enough?
Should be plenty of time, sir.
Or do you want less? Take 10. If you need less.
I'll take 10. If I need less, I'll let you know.
Okay, so we're going to suspend briefly. It's now 7:27. Let's come back at 7:37. Okay, we're back in session. It was about 5 minutes. Thank you for being prompt, Ms. Brewer. What I'm going to do is I'm going to turn this meeting over to you briefly so that you can make your presentation. And most specifically, when you make your presentation, I want you to address the issue of jurisdiction, which, as you and I both know, and Ms. Sheehan as well, because we had this conversation before on the other case, that's the threshold issue on all cases. So let's talk jurisdiction. Do we have jurisdiction over this particular case?
You do.
Tell me why.
The main reason is twofold. One is we have met the deadline for filing, which was one of the grounds for your former decision, the one that I just read.
That's true.
Secondly, the differences in the zoning bylaw for the treatment of earth removal between the RA district, which was an issue in that one, and the SSID district, which is the one that's before you tonight, is critical for your jurisdiction. Because under 2230, earth removal is prohibited under the zoning bylaw for the SSID. That is not the case with the RA district. In the RA district, it is permitted so long as you get an earth removal permit. But that is not the case that we have here. It's actually a pretty simple issue, that the use regulation schedule in the zoning bylaw specifically says that earth removal is prohibited. It is ongoing under the current operation, and therefore it's in violation of the zoning bylaw.
Are we making a distinction without a difference here?
Oh, gosh, no.
Why? Tell me why.
Because one's a Y and one is a no under your use regulation schedule.
Let me pull that out and take a look. Does everybody,
I have a copy of it here if you need it.
I have a dictionary here. So you're looking at 2230, true?
Correct.
And you're drawing our attention to what page?
It is page 3.
And you're looking specifically at what on my page 3 anyway?
The line for earth removal, the row.
That's not on my 3.
Yeah.
Next to the bottom.
Yeah, it is.
Oh, there it is, yes, now I see it.
And if you look across, you may have to turn to page 2 to see what the...
No, we can see it.
Okay.
Yep, we can see the SSID is the very last column.
Yes. And the RA is the very first column.
So again, your argument is that the first case that we ruled on was an RA case, or a district RA, and that this case is a totally different zoning district,
Correct.
which thereby gives us jurisdiction to proceed on the merits. Is that
Correct.
your argument in a nutshell?
It is, sir.
Can you hear everything, Ms. Mello?
Yes, I can.
Okay. So after generating that explanation from you, and thank you for being succinct, I'll throw it over to the board members for whatever questions or comments they'd like to make.
Well, I'm also seeing next to the words earth removal, you'll notice that there's a plus sign next to that. And if you go to the bottom of page 7, it says, allowed by right with approval by the Earth Removal Committee under the general bylaws.
Correct. For those columns that have a yes, a Y, that cannot be the meaning for the Ns, the districts with an N, or prohibited or excluded use, because otherwise the difference between Y and N is meaningless.
Does that address your question?
It does.
Okay. Do you have any?
Nothing to follow.
Oh, you have the
Yep.
floor. Mr. Barrington, what do you got?
Do we know if the planning board has issued a special permit for the commercial development there?
It has in fact not. I know that's what the building commissioner said is one of his 2 reasons for denying it, but what it issued was a definitive subdivision plan, which was approval, which was not a special permit.
Okay, and the same thing with the soil removal permit?
Presumably, that is the earth removal permit that was issued. However, the earth removal committee cannot override the zoning bylaw.
Do you have copies of those permits?
I do. This is the earth removal, And this is the definitive subdivision approval.
Thank you.
Are those your file copies?
They are, but you
But
can keep
we'll give them back to you. How's that?
Thank you.
I'll just make a note of the books and pages. And what did earth removal say when you went before them?
We have not been before them yet.
Shouldn't that be your
Just-
starting place?
We have started that process.
What does that mean?
We've sent them a letter telling them that the conditions in the 2018 permit that I just handed to you have been violated
And what's the date of that letter?
yesterday.
And they haven't responded yet? I'm shocked.
I know, me too.
Was that by certified mail?
No,
So that was an email?
no, that was by mail.
Regular mail?
Yes.
It'll be a few days.
At least. Ms. Clark,
Yep.
further?
I'm still stewing.
Yeah, I am too. I don't know why you folks have chosen, and maybe there's some tactical reason or strategic reason for this legally, why you've chosen to put the Earth Removal Committee on notice as of yesterday of your concerns with regard to these sites. It is their permit which you're alleging has been violated, or the scope of which certain people have gone beyond. Is that right? So notice went to them yesterday, and I'm not remarking about whether the notice is proper or not. What I'm remarking about, what I'm baffled by, is why you waited this long to come before, or to request a hearing before the Earth Removal Committee. I'm assuming you're requesting a hearing on your concern, and that this was just sent to them yesterday, and here you are before us tonight. Can you explain, or do you wish to explain why you've chosen to give the Earth Removal Committee such a late letter on this matter?
I don't think one has anything to do with the other.
It may not, but from standpoint of committees and boards stepping on each other's toes and being asked to review basically the same case, why would you not have started with the Earth Removal Committee? It's their permit.
It would be stepping on the Zoning Board of Appeals' toes for the Earth Removal Committee to do anything as to the zoning bylaw. I'm only here on the zoning bylaw. And the Earth Removal Committee will do what it will do, but that does not take away any of the authority and the enforcement obligations of this board.
Okay, I hear what you're saying, and I'm not sure that I understand why you've chosen to come here before the Earth Removal Committee and address this with them, but I do have another question for you, if no one else has any questions at this point. Ms. Mello, do you have any questions at this point?
No, I do not.
Okay.
Can I ask, is there a
Yes.
member of the Earth Removal Committee in the audience? Okay.
Where is your standing in this case?
So all of the abutters to this operation, the strip mining operation, are members of the Save the Pine Barrens nonprofit.
Doesn't it have to be individualized harm?
Oh, they are very much individualized harm.
Well, that's conclusory. I don't know who these abutters are. I don't know if they're all lined up in favor of what it is that you're asking us to do. So I had some concerns as I read through this about whether there was, in fact, any individualized harm that's being alleged here. I didn't see it. I saw, obviously, the Save the Pine Barrens group fronting this for other unnamed individuals that you're claiming were harmed individually here. But are there any abutters here tonight to any of these pieces of property or this particular location that Attorney Brewer is referencing? Nobody here. No abutters. So I have concerns about that issue, whether there is individualized harm sufficient to allow you standing to present this case. It's another threshold legal issue before we get to merits. So as I read through this and as I listened to you tonight, and thank you, you're very eloquent, my sense is that maybe we should seek opinion from town council on not only the issue of standing, but also on whether we should be assuming jurisdiction here under the bylaws, under a permit that was granted by the ERC, and that the ERC has just been made aware of there was an issue with as of yesterday. So I feel like I want to reach out to town council on this. Can you hear me okay, Ms. Mello? And have her opine or give us some guidance or direction. We all speak the same language here, so I think I'll be able to gather what it is that she's telling me, and I promise that I will share that with both of you, Ms. Sheehan as well. But that would be my inclination this evening, is to get some direction on these threshold issues. Now, I know that probably most of you here tonight want to talk about what's going on over there. You're concerned about the environment, about the mining that's going on, and perhaps without proper authority, beyond the scope of the permit that the ERC granted. And speaking for this board, not just for myself, but speaking from the chair, we all have concerns about activity that might be unauthorized or beyond the scope of proper legal authority that's been granted. That's not what we're talking about tonight, though. Before we get to that, we've got to get through these threshold issues. And as you referenced before, that case that we had recently was similar to this case in some ways. So we're not unfamiliar with this alleged problem that's going on in town. And like anybody else, we're concerned with our environment and with our water. These are, as I've explained to Ms. Sheehan before, important issues. So for us, we don't make any judgment tonight about the merits of this case. What we're concerned about is jurisdiction. That's not a dodge, that's a legal requirement. Without jurisdiction, which is just a fancy legal term for the authority to hear a case, without proper jurisdiction, we can't rule on the merits, on anything. Ms. Brewer, do you have any final comments this evening?
I do.
Proceed.
Thank you. I have a couple of reactions to how you have framed the issue for town council, and I would ask you to consider this.
Okay.
First of all, the earth removal permit from 2018 is irrelevant to the question before this board. The simple question is whether earth removal is permitted in the SSID. The ERC cannot override the zoning bylaw, so whether it issued a permit or not is irrelevant. The N in the use regulation schedule says that earth removal is strictly prohibited in the SSID. Your zoning bylaw specifically says that no board is able to grant a use variance. That is what would be required to permit earth removal in the SSID, and you cannot do so. Secondly,
I'm sorry, continue.
I'll be quick about
No, that's okay, you're doing fine. Go ahead.
My second and final point is that once this board or the building commissioner is aware of a violation of the zoning bylaw, you have independent authority to enforce your zoning bylaw against violations, and I would request that you do so.
Okay, so that's basically a rehash of what you said initially, but I wrote down one question that you asked us specifically to propose to town council. Is earth removal allowed in the SSID? Is that what you want us to ask, or one of the things you want us to
One of the
ask?
things that, yes.
Okay. So, like I said earlier, I promise to share the opinion of town council with both of you. And we will come back at this at our next meeting or the meeting after, depending upon how much time you feel you want to space these hearings out for. Does anybody else have any questions, comments, or observations? Ms. Mello? Everybody good? I do, in observation of all the people who are here tonight and obviously concerned about this issue, ask that you bear with us while we work through the legalities of this. Again, this is not a dodge or a duck. This is an attempt to get it right legally. And you've heard Ms. Brewer speak, as I said, eloquently to the issue that she feels is apropos, or the issues that she feels are apropos to allowing us to exercise our jurisdiction. We, I think, still have some questions about this on which we need guidance. But for those of you here who are here tonight, does anyone have any questions, comments that they'd like to raise? All right, go ahead, gentlemen.
Name and address, please.
Yes.
Peter Opachinsky, 50 Old Sawmill Road, Kingston, Mass. I'm the owner of the Ricketts Pond Business Park.
Thanks for coming in, Peter.
Yep, no problem at all. Back in 2018 was when we obtained the permit for this property.
Yes, sir.
And it was in advance of us obtaining an approval from the planning board for a commercial industrial park, which is what the vision for the Spring Street Innovation District was. And because of the topography of the land, the highest point being about 80 feet higher than Spring Street, the only way to develop the property and achieve the grades that the planning board would accept as far as pitches on roadways and whatnot was to level the property with Spring Street. And that also provided my access into Plimpton, which is about level with Spring Street. So I think if you look at your own zoning chart, the earth removal that everybody's looking at is under residential section. It's not under commercial. And one of the first things that I did when we bid on the project, we bought this property through Mass DOT. It was land that was surplus to the state after the building of Route 44, producing zero taxes to the town of Carver. Was they were looking for the best use of the property. So we submitted a plan to Mass DOT. I think people in town had a chance to see what our plans were for the property. We provided plans, we showed what we're going to do. You couldn't have built in the Spring Street Industrial Innovation District without doing some form of earthwork and earth removal. It would have been impossible to develop the land. So I think the table is flawed in the fact that it only addresses earth removal for residential use, ours is commercial use.
Okay, well, let me just, with the permission of the other board members, address that last allegation.
Okay.
That it's flawed. And it may very well be, but it is what it is what it is.
Sure.
We don't make up the law.
Right.
We enforce it.
But would you agree my use is commercial, not residential? That's what was approved by the planning board. And that's the reason the earth removal...
Do we have that
It's
decision?
right there. I can't reach it now. I'd have to get up. I've been here since 6.
So we'll obviously review that. But, you know, for as long as I've been sitting on this board, and the young lady to my right who's sat on this board even longer, we sometimes encounter cases where we really wish that we could do something else. But we're not here to apply our own personal beliefs or our own political preferences. We're here to apply the law. And occasionally break it in the form of variances or the granting of special permits. So I appreciate what you had to say. I heard every word, and I know everybody else did too. But we have to go with the way it's written. And so you may not like the way it's written, and in fact, it may very well be flawed. Your word, not mine. But this is what we got to deal with. But thanks for that. Who else would like to be heard? Yes, sir. What's your name and address?
My name is Dan Perini.
Dan.
Plastic Road.
Thanks for coming tonight.
Thank you. I've got a question. I heard this gentleman, I don't know him, I'm just sitting and listening to this argument tonight,
Yes.
said that he has residential property, but he's turning it into commercial property. Don't you need a special permit to do that? That's what his statement was, that he has residential
think that's
property,
what he
he's
said.
turning into commercial property.
I don't think you said
That's what
that.
I understood him just to
Okay.
say.
Peter, you want to clear that up for
I said-
Dan?
If you look at the zoning table, it shows earth removal under residential use. Doesn't show it under commercial use, and my use is commercial. Residential is not allowed, basically, in the Spring Street Innovation District.
But again, you just said that the property is residential. and you're using it as-
No.
That's the way I understand him saying it.
Okay, I think you misunderstood what he was
I
saying.
think he used the word subdivision because it's a business park
Yeah, it's a commercial subdivision.
It's a
We have
commercial
industrial
subdivision,
lots
and
there.
most of us automatically think of, 12 houses on this much space.
Does that help?
Yeah.
Thank you. Who else? Oh, all these people, but only 2 people raised their hands.
No, if I may, Mr. Chairman.
You may. Your name and address,
Alan
please.
Jermaine, 24 Pine Street.
I know where you live.
I know you live too.
Yes, you do.
I'm gonna have to question that I happen to agree. I think that the way this is written is in error, and I don't think it was the intent of the bylaw. If we look down to general business, we'll see that's also prohibited. So it's impossible to develop any commercial site without removing material. In fact, we have sites that we're removing material and bringing material back into. The town requires earth removal permits for this process. I still have to go with the plus that says allowed by right. This property was bought from the state. You can't build a commercial industrial park on top of a mountaintop. So the state required, this wasn't just a great idea, the state required an innovative use. I happened to speak with Stephen Cole today, and he said there were many applicants, one wanted a gas station, one wanted a convenience store, and the state didn't like any of that. So I would have to go, my question would be for council, to look at the asterisk after earth removal, because I really believe that when you get into the commercial stuff, it requires you to get an earth removal permit. There aren't too many houses that people are building that the individual homeowner has to come in and seek an earth removal permit. But every commercial project requires an earth removal permit. So I think it's an interpretation. I don't think the intent of the bylaw was ever to exclude all earth removal. You could never build anything. Thank you.
Okay. And that's probably how we'll definitely frame one of the questions to council, is to interpret those 2.
I'm sure we can back up enough too and try to find out where this was adopted. Although I see the same language going back 10 years in the bylaws, so.
Could I also add something?
You may.
I have purchase and sale agreements on every single lot in the subdivision that we had approved by the town, and with closing scheduled for May and June. So if this comes out the way I hope it does not come out, I'm going to suffer severe financial harm. I just want to make that known at this time.
Understood. Remember, though, everybody, what I said before. Hold on, Michelle. And Mr. Jermaine, this is an observation, does not require a comment from either one of you. Sometimes laws are not written very well. The 3 of us know this. And it may or may not be accurate that the way this is written is poor. It may or may not be accurate that it's confusing. We will get the guidance that we need from town council and the collective guidance of this board, and we will come back and make our best and most considered judgment. You have that guarantee from us. If you know this board, we, as I said, review things carefully, we consider things carefully, and we haven't been reversed in a very long time. Ms. Clark?
Hello?
How many years?
30. Oh, have I ever been reversed?
No.
That would be never, and I've been on the board 30 years.
And that cannot be said for the other boards in town. So we're very careful, and that doesn't mean to say that we're infallible just because nothing's come back from the courts contrary to what we ruled initially. Does not mean that we're infallible. What it does mean is we have a good record and we're diligent. And sometimes we have to make decisions that are not very popular. But again, we're not politicians, we don't stand for election, and the court cases refer to the zoning boards of appeals in the Commonwealth of Massachusetts as quasi-judicial boards. So we sit, in essence, as 5 judges without the robes. And I guess that's all I wanted to say. I recognize that there are ambiguities in the law. I recognize that sometimes the law can be confusing, interpreted in different ways, and maybe interpreted in ways that were not originally intentioned. But we'll figure this out as best we can. Ms. Sheehan.
Sure.
Nice to see you again tonight.
Thank you, Chairman. I just want to respond to some of the points that were made by Mr. Jermaine and Mr. Obuchinsky about the project and the alleged necessity by the state for this type of development.
Proceed.
My understanding is that this property was spot zoned SSID simultaneously with Mr. Obuchinsky's pursuit of the purchase of this excess property from DOT, so there is no other innovation district like this in the town of Carver. So it was rezoned so that Mr. Obuchinsky could get the piece of property from the state and put some kind of innovation district there. I have read through most of the state documents. None of them require earth removal of this scope and scale. And to imply that a 5+ year earth removal operation of at least $9 million worth of sand and gravel was necessary to develop this and somehow required by the state is wholly inaccurate.
Okay.
And this operation is and has been going on since prior to 2018, before they even got the earth removal permit. And as you may be aware, perhaps you're not, some of the abutters have sued the earth removal committee in order to prevent the expansion of this property around the other side of Ricketts Pond. So that will continue the operation for another 2 years. And they have filed very detailed affidavits with the Superior Court detailing their harm and the harm that they have suffered as a result of this.
Anyone else have any questions, comments,
I'll make a
concerns?
final comment that I'm going to leave, Mr. Chairman. At the conservation meeting, it was $7 million that he was making off the year. Now it's $9 million.
Well,
Went
yeah,
up
you
$2
were
million
saying
in a week and a half. That's good.
Okay.
Good to see you, by the way.
So, Mr. Chairman, can I make a comment? Jason Martin, SLT Construction.
Hi, Jason. Nice to
How are
see
you?
you.
Very nice. So actually how this property was found by SLT was at the Village Cafe in Plimpton. I was having lunch, very nice little spot. Plimpton Reporter in the back and the legal had an ad that Mass DOT was sponsoring a sale by auction of this property, and it was listed right in that advertisement that it was in the Spring Street Innovation District. This is the first time we became aware of the property or its zoning. Any earth removal that was done prior to that or prior to our purchase of the property was done by others. It had nothing to do with SLT Construction, Ricketts Pond Business Park. It was a deal between another abutter and another sand and gravel operation in town. So that's wholly untrue in itself.
Like if somebody was stealing sand and gravel on.
All right, we're getting into the merits now, and
We're not getting into that.
we're not going to get into that.
Done the research.
So he cleared up in his mind some of the history
Right.
that differs from some of the history that
We
you
knew it was
presented. We recognize that there's
innovation.
different perspectives and viewpoints here.
Correct.
Now, Ms. Brewer, I want you to do something for me. You have 2 or 3 questions that you have asked me to propose to town council. And I have written down what I think you view as a primary question, maybe the primary question, which is earth removal allowed in the SSID district? And I would add a question to that as well, which is, to what extent does this board have jurisdiction over the petition which has been filed by the Save the Pine Barrens group? I would ask you to provide the planning department tomorrow, and they will turn this around and get it to me, I assure you. Any other questions, 3, 4 questions, that's what I'm going to allow you, that you feel should go over to town council, so we can get addressed those specific topics that you feel we should be given guidance on. Is that a fair request?
It is, sir. Thank you.
Thank you. Does anyone else have any questions, observations, concerns? Everybody good tonight for now? So, we have a meeting in April and we have a meeting in May. Ms. Mello, you following okay? You can hear?
Yes, I can.
Thank you. I'm going to ask now, though, for a motion to continue this case to our next hearing date. Not our next hearing date, but to a hearing date, which we will discuss in a moment.
Okay.
So, do I hear a move? Yep, and a second. And before we vote on this, do you have any objections to continuing this case to our next meeting?
No, sir.
No objections from the petitioner. All in favor?
Aye.
Okay,
Aye.
thank you. There's a little bit of a delay, you're throwing me off.
That's, our next meeting's in 2 weeks.
All right.
Yeah,
April 5th.
April 5th. So I think probably this should go over to May. Would you agree?
I doubt town council will be able to get you an opinion that quickly. I know that it is prime annual town meeting time.
Yes, it is. Thank
So
you
that's
for
a
reminding
problem
us.
For town council.
So,
So your next meeting?
It's May.
After April is May?
May 5th.
May 3rd.
May 3rd. How's that?
It was close.
May 3rd.
May 3rd.
Is that okay?
Yes, sir.
Now, we have 3 cases on for that evening. Now, and these other cases are, one of them is a dual-use solar project case. Another one is a case where someone's trying to build a couple of different residential structures on the same lot, very close to water. I mention this to you because these cases are not likely to be 5 or 10-minute cases.
Yeah.
So if you want us to consider scheduling a meeting just for you, I would not be opposed to that. That way, everybody can come in, say what they want to say, you especially, and Ms. Sheehan especially, and then hopefully we'll have been given direction at that point. I would expect that we will have been given direction at that point by town council, and we can have at it and hopefully arrive at a proper decision that evening. So I leave it to you in consultation with your client as to whether you want to stay to the May 3rd date or whether you'd like a different date.
Yes, sir, we would like a separate date.
Sir was my dad.
You earned it.
Okay. So we're looking for a May date
Or earlier in April.
or...
I mean, after April 5th.
Yes, yes.
Between April 5th and May.
Later in April. Is everybody okay with that approach? Because given the public interest in this case, I really don't want to have to hold everybody in here while we go through 2 other cases, both of which are
makes sense.
likely to be lengthy cases if they go forward. Remember, both of those two cases that are coming up in April have already been continued because there's jurisdiction with the Conservation Commission, there's jurisdiction with Planning Board, there's jurisdiction with ERC on these other two cases, so a lot to go through. So I wouldn't want to hold everybody up either. So let's pick a date where we can.
I'm going
do
to
this.
ask that the date be in May.
I say, you got things going on in
I
April?
cannot work you in other than April 5th.
Okay. So it's going to have to be May. So we've got one date of May 3rd. You want to do a second meeting the same week?
No.
Well, that's quite firm, isn't it?
I'm going to ask the question, I'm going to give the answer.
All right.
I can do the following week,
Which would be the
10th.
10th.
9th or the 10th.
Mr. Barrington?
May 10th?
May 10, yes.
Ms. Mello?
Yes,
Ms. Clark?
I'm good.
You didn't
Ms.
ask me.
Brewer? I didn't. Yes, you did. Yes, I did.
I'm good.
You said. Ms. Brewer and Ms. Sheehan, is May 10th okay?
May 10th is fine.
Okay. Before we leave this tonight, does anyone have any final thoughts? We're pretty open about listening to everybody. So, anybody want to be heard? Okay. Thank you all for your patience tonight. We will continue this case. Should we do a vote? Why don't we do a
No,
vote?
we already voted to continue it.
That's right, so we're going to continue to May 10th. And that will be a date that we will hold for you. First case out, last case out.
Thank you, Mr. Chair.
It won't require another public notice, so this is the public notice.
And you're going to get to me by the end of the week, 2 or 3 or 4 questions, no more?
I thought I had by tomorrow.
You gave it till tomorrow.
Well, I'm going to give you 2 days, how's that? 2 days. You're busy tomorrow, aren't you? I know you are.
If you give me till Thursday, I'll take it.
Take it.
Or wait.
Today's Tuesday, you're right.
Today's
2 days. All right, so thank you. Just ask, on your covering email, just ask the planning department to get that over to me.
Will do.
Oh, yeah.
Thank you.
Thank you.
And do we have copies of those? I don't
I'll
think we
make
Do you want me to leave these?
No, I'll make them.
No, those are her file copies. We'll make them on our end.
I'm an examiner, so.
Thank you, everybody. Thank you, Ms. Sheehan.
Thank you.
Thank you.
I'll send those around tomorrow.
Oh, yes?
Drive carefully.
Thank you. Good night, everybody.
Good night.
I had, so,
Someone left a jacket.
you want the high school as well, so.
Man's jacket.
The guy who was,
Yeah, the SLT guy left his jacket.
your jacket,
Jacket!
your jacket?
Thank you.
Yeah,
We don't want you to be cold.
No, thanks.
no, we had some great teachers in that era.
Okay.
Always remember.
So we are still in session. I do want to ask if anybody, there's no correspondence that we have received, other than the request for continuance, which we granted on the Antoniotti case.
Okay.
Is there anything else that anybody would like to raise at this point in time?
No.
No.
Ms. Mello is shaking her head in the negative. I don't think we have any other business then for this evening. Do I hear a motion to adjourn?
So moved.
Second.
All in favor?
Aye.
Good night, Carver. Thank you for being with us.